Gang, what's up? Aaron here, Canadian Looney. It's a strange time in Canada. We have a prime minister that's selling sacrifice now to our youth. This guy doesn't even pay his taxes. That's weird. We're going to take a peek here at Vassy Kapelos interviewing our Attorney General, Justice Minister, Fraser. And Vassy Kapelos could be a capable journalist. She's shown evidence of that in the past, but recently she's been a liberal cheerleader most of the time. Let's take a peek. Let's see which version of Vassy we're going to get. I'm pretty sure we know which version of our Justice Minister we're going to see. Let's take a peek.
Hey, that's something everyone can enjoy.
Deem that unconstitutional. It would also restrict conditional sentences if the bill passes into law. Fraser is the Justice Minister and Attorney General. Hi, Minister. Welcome back to studio. Good to see you. Thank you for making the time.
It's good to be here with you.
Is this legislation a concession that your government got it wrong for the better part of a decade?
No, this is a response to the very real concerns that we've heard directly from Canadians. We hear in different parts of Canada different concerns, but overwhelmingly there's enormous consistency with Canadians writ large, with law enforcement, with provincial governments, that they wanted to see changes to bail laws and stronger sentences for serious crimes. So this is a response to the lived experience of Canadians that they've shared with us in advance of the last federal election and since, to make sure that our laws are up to the standard Canadians expect when it comes to protecting their families.
But the laws that were in place prior to the introduction of this legislation, should it pass, were laws that the Liberals specifically put on the book. So we'll start, for example, in 2019 with C-75, which introduced the principle of restraint, codified the principle of restraint, led to a lot of backlash from law enforcement, federal opposition, as well as premiers who were asking for bail reform at that time. Your government introduced bail reform in 2023. Clearly it didn't go far enough, or we wouldn't be here today. Why should Canadians trust you to fix a problem that you had a hand in creating?
So we will always want to iterate in response to the concerns that we hear from Canadians. There are certain elements of the laws that you've referenced that remain in effect today that actually do good things, making it harder for people charged with intimate partner violence to be released on bail, for example. But we do need to go further, and we need to acknowledge where the laws that we put in place under the previous government need to be changed. We can't dig in and insist forever and a day that we've always been right. When we hear from Canadians and from law enforcement and from provincial governments who run the bail system that we need changes, we should take those concerns seriously. What I'm confident in, though, is that particularly with the validation we've seen of this bill from our law enforcement partners and from provincial governments, is that we've hit the mark. The new laws that we're introducing today are going to improve public safety when it comes both to bail and when it comes to sentencing for serious crimes that have been committed across the country. Is
there a substantive reason beyond just pressure from political actors for you to introduce this legislation, or is it inherently political? Are you doing this because, for example, the issue of crime and your perceived weakness on it cost your party a majority, or are you doing it because you think it will actually fix a problem?
So we are orienting the entire initiative behind what's going to help keep communities safe. We have heard very directly from people, less about their political concerns and they want us to match a provincial government or another party. We've heard that they're scared. People are afraid in certain communities and they want the law to protect them. Now, we think this is going to make a meaningful difference when it comes to improving public safety, but we also know that the job isn't done. We're going to have to work with law enforcement and with provincial partners, again, who run the system, to ensure that the changes we make have the resources behind them to actually be implemented. But we also know that the conversation about public safety is broader than bail and sentencing. Yes, we need tougher laws, not just on bail and sentencing, on intimate partner violence, protecting kids online, combating hate, but we also need to make the investments on the front line with law enforcement to help protect communities and prevent crime, and to make the upstream investments in the long term around affordable housing and mental health to prevent crime for the long term.
So on the first part of when you're talking about additional resources, I think what really struck me is when I think back to the introduction of C-75, the stated purpose at the time was to do two things: address overcapacity in the jails, in the correctional system, and to address overrepresentation of minorities in the justice system. On the first, when you talk about additional resources, I listened to your press conference today. You firmly put the ball in the province's court. You said, hey guys, and I'm paraphrasing, but hey guys, you asked for this. You're going to have to make sure that it does what it's intended to do and deal with overcapacity. There are major overcapacity issues. I believe it's 100, some correctional facilities in Ontario are operating at 150% capacity. Are you going to, in this budget, put additional resources to addressing that? Because what you're introducing today will certainly compound that problem.
So what we introduced today was a response not only to the Government of Ontario, but I should take this opportunity to thank them, and in particular my counterpart, Attorney General Doug Downey, for his collaboration in developing some of these reforms. But one of the things that we learned through our extensive engagement with provincial partners is that the challenges in one province don't necessarily reflect the same challenges in another. Where it may be detention facilities in certain provinces, it could be Crown prosecutors, community policing may be a bottleneck in others. There are different systemic challenges that appear in different parts of the system in different regions of the country. The measures that we're putting in place today had virtually unanimous support amongst provincial governments, and given that they are responsible for administering the system and they wanted these changes, we certainly expect that they're going to match these changes with necessary resources. Now, we're going to remain at the table to have conversations about what the appropriate role for the federal government is, particularly in areas of federal jurisdiction, but this is a conversation where I'm not interested in picking a fight or pointing fingers. I've had a very positive experience working together with provinces who I think get it, who I think want to solve this problem, and we want to be a meaningful partner who does our job, and we expect that they're going to do theirs as well.
But what is your job? Because my question is about what happens if the problem you thought C-75 was going to fix ends up getting a lot worse by taking away some of what was put in place. And by that I mean that the justice system becomes even more delayed and more fraught with additional cases that can't be handled in a timely manner, and that the correctional facilities become even more at higher levels of overcapacity. I take your point that it's not in every province, but there are some pretty staggering statistics about capacity in nearly every single province. So what is your role? Are you prepared to put more resources if necessary?
So in terms of our role, we certainly own the text of the criminal code. And when we're delivering on the measures that Canadians are asking for, I can't in good faith say that because there are challenges with capacity and detention, that we should do something less than put forward the laws that we think will promote public safety. We have to start with
that's basically what you did with the last government.
This is a new government, and there is a different approach that's being taken. I am...
Same party, to be fair.
Yeah, certainly, we are the Liberal Party of Canada. You're right about that, but I can tell you the focus that I'm taking to this particular initiative is designed to ensure that we have a legal framework in place that will promote public safety. To the extent that there are downstream implications within the system, we want to work with provinces. That may include, I got a question at the press conference today about reviewing the judicial complement that certain provinces are facing based on the caseload in their courts. When it comes to the operation of the provincial court system, of the bail system, where disproportionately the responsibilities fall to the provinces, we do anticipate that they're going to need to inject resources into the system.
So will you provide them? That's my question.
Look, I am not broadcasting budget decisions that have not been made public, but my goal here is to figure out if there is a mess in my own backyard, I want to clean that up first. We've taken a major step in the right direction with the legislation that we've tabled today. To the extent there are other areas that fall within federal jurisdiction, whether that's federal RCMP, border officials, whether that's the judges whose costs falls to the federal government, there are spaces where we need to continue to do our job. But my sense is working with provinces, they know what their responsibilities are and they want to take action as well.
If the problem is violent criminals out on bail recommitting crimes, are you certain that this time, this sort of second shot at things will actually, as you put it, solve the problem to the fullest scope that it can? And I will sort of back end that question by saying, why not repeal the principle of restraint?
Certainly. So the challenges are so much broader than any one principle. I do think that the legislation we put in place today takes a meaningful step towards addressing public safety concerns that are very real that we've heard about. But we know that in order to solve the problem, we will need those provincial governments to step up with resources. But we also need to make the upstream investments that I mentioned at the outset of this conversation around mental health and addictions, around affordable and supportive housing, around programs for youth. If we want to take a long-term view, these are the kinds of things that will prevent crime from taking place in the first place and will have a profound impact. But we have to take action in the short term, A, to help improve public safety, but B, to ensure that Canadians have faith in the administration of justice.
I'm not sure that answers my question. Why not repeal what you codified and led to this issue in the first place, which is the principle of restraint? Why still have that on the books if it has in any way contributed to this issue?
So the principle of restraint, if you repealed precisely the section that was adopted in Bill C-75, would still exist because it didn't come from the federal government. It came from the Supreme Court of Canada. Its codification, in my conversations, has led to the misapplication of the principle of restraint, in my view. We've taken a major step with the legislation we've tabled today to significantly adjust the language in the criminal code about the principle of restraint, specifically saying that bail hearings are not going to mandate the release of a person, and if you're going to contemplate the release, you have to be satisfied that they don't pose a threat to the public safety or to the public's faith in the administration of justice. This is a significant change that will change the way that the principle of restraint actually operates. We want to ensure that public safety is a paramount concern when courts hear cases about bail, and frankly, about sentencing as well. But to answer your question, this is a major change on the principle of restraint to recognize that it has been applied in a way, in some instances, that we hadn't intended under the previous government when that legislation was put forward.
And I take you at your word, but when you were saying that, I literally had a flashback to 2023 when the person who occupied your position was saying the exact same thing. Basically, we've taken a step, we think we'll address what the principle of restraint, the codification of it, led to, if I pull up the quote, the laws on bail that we currently have are clear. If one poses a threat to society, he or she should not be out on bail. Ultimately, it didn't go far enough. What if this doesn't go far enough? Why are you hesitating to use like the maximum amount of tools you have at your disposal? Why keep any remnant of that principle on the books?
Well, this really came from the engagement process with law enforcement and provincial partners in particular. Though you do hear calls in the House of Commons about this one very specific narrow issue, that is not the main source of consternation that we heard amongst Canadians or the people who work within or manage the justice system. Overwhelmingly, they told us that we needed to adopt the kinds of measures that are included in this bill. We could probably get a political point with our opposition in the House of Commons by just doing what they want. But I would rather take my advice from the people who work in law enforcement and the people who manage the justice system, who understand the challenges that are actually being experienced as these things play out in real time.
I'm not asking just because of politics. I'm asking because I've had this conversation with your predecessors
Sure.
on numerous occasions, and I was told the same thing, this is going to work, and it didn't. Ultimately, how will Canadians know? How will they be able to judge whether or not this legislation does go far enough?
Well, one of the things that you'll find with my approach to this file, and frankly, just life more broadly, you have to continuously look for ways to improve the job that you're doing. We are going to monitor, in collaboration with provinces and territories, the impact that the measures that we've just put into legislation, or put into a bill rather, that's going through the House, we're going to monitor the impact that they have. We are going to need to partner with provinces and territories who are in a better position to collect data about that, to understand whether the measures are having the intended impact. To the extent they are, that's great news, and we'll be happy about the improved public safety circumstances Canadians enjoy. If the laws are not having their intended effect, then we need to continue to revisit how they may be changed. But just a final point on this. We have to understand why policies work or don't work. Sometimes it is the text of the law. We've made some changes today. Sometimes it's whether the system behind the law are appropriately resourced to deliver justice to Canadians.
But like in a black and white way, Canadians who are watching tonight who are concerned about people who are out on bail committing violent crimes, like, do you anticipate what you're doing here will lead to fewer of them doing that?
I think to start, remember when you're dealing with bail and sentencing, you're dealing with people who are before a court after a charge has been laid, typically after a crime has been committed. Certainly there's a deterring effect when you have stronger sentences that could prevent future crime, but this is about delivering justice for people who have been charged with a crime, who have been convicted and are being sentenced.
Justice for them?
No. Delivering justice for Canadians when those circumstances have been presented, obviously, and thank you for the clarification. There are other measures we need to do to help prevent crime as well, including those upstream investments, including more support for the front line, whether it's at the border, whether it's in our communities. You can't hive off a narrow portion of the justice system and tell Canadians that this one thing is going to solve all of their problems, but you can say this is an essential step towards a more complete picture of the strategy of how we're going to improve public safety. I'm confident it's going to have a positive impact. To the extent that we need to take further action in the future, we're going to keep an open door for ideas that come in from partners in law enforcement, with the provinces, or with Canadians more broadly, to understand how we can deliver better public safety outcomes in every part of the country.
I'll leave it on that note. Minister, a pleasure. I appreciate your time.
Yeah, thank you so much. It's good to see you again.
Thank you so much.
Oh, yeah.
What do you guys think? Vassy did a pretty good job there with our Attorney General. He's trying to divide, distract, confuse people with plans. The simple thing to do would just be repeal these bills. But nope, Sean Fraser has different plans that are going to be better for Canadians. What a whack job. Aaron Canadian Looney, thank you very much for watching. We'll catch you in the next video. Get your Canadian federal politics right here. Everyone has an opinion about Canadian federal politics. Catch you in the next video, gang.